Hello, hello students. We have to know before the constitutional law. Our subject is constitutional law, but we have to know what is constitution, what is constitutional law, and what is constitutionalism. These three terms are very much commonly used, very frequently used, and what are the differences between them? This is the most important thing. First, what we are studying, that is the constitutional law. The difference between constitution and constitutional law, that we have to understand. What we are studying, being the student of, being the citizen of India, we have to know, being a student of law, we have to know the constitution of India. But constitution of India is just a mere statute. It is consisting of the articles and your provisions or rules, regulation, preamble, all of this with some schedules. But this is the statutory structure. This is the very much mere law, mere statute, act. But constitutional law is the ethos and principles that why this provision came into existence, its historical background, comparative analysis with the other constitution. Apart from that, that what are the various cases have been decided on this provision and the role of the Supreme Court and other constitutional courts in this field. So constitutional law comprehensive study of any provisions in detail, its origin, its source, as well as its impact and latest decision of the courts and the other constitutional court in this matter. Next, if you see another term is coming, that is the constitutionalism. Now, what is constitutionalism? It is another important thing to understand, because constitutionalism, it is said that constitution is there, but there is no constitutionalism. Constitutionalism is the basic values, the ethos, the principles on which this constitution was framed. A particular constitution of any country has been framed. Some fundamental principles are there. Suppose rule of law or res judicata. Those are principles of law which we will understand time to time during our in-depth study. Those terms are missing, means those philosophies are missing. So philosophy of the constitution, the basic values of the constitution, that is actually constitutionalism. So this is a difference between constitutional law and constitutionalism. Now if we come to from very beginning, what three terms we have to deal with. One is Constitution of India, or you may say the simple constitution, which is the combination of some statutes, some provisions, some articles, some schedules. Next, the constitutional law, where the various case laws are coming, constitution plus case law, or suppose any kind of sources of law, or that's interpretation of this particular provision. Whereas constitutionalism is the basic philosophy, the ethos, the values inside, inherent inside this constitution. That is the constitutionalism. And point to point, we will, in our detailed study, we will be able to understand how constitutionalism is different from the constitution and constitutional law. Now, again, we have to understand some terms which you will not find inside the constitution, but time to time courts have interpreted. So in the constitutional court, in the Supreme Court as well as high courts, they have interpreted, they have borrowed some principles from the foreign constitution, or they have borrowed some principles from the international conventional treaties or international law, and they have adopted those policies, those principles, those terms in our own law of land, and it has become our sources of law, one of the source of law. Suppose the constitutional morality. Nowadays, everywhere you will heard some cases have been decided recently on the constitutional morality. Now, to know the constitutional morality, you have to understand the every nooks and corners in detail of the constitution, why this provision came into existence, and how it has been interpreted, and what are the various cases, and how Supreme Court and High Court analyze those principles in the modern term. Suppose in your recent case, perhaps everyone is aware about this constitutional morality. Recently, your case of your suppose triple talaq case recently, or suppose Sabarimala right to privacy case, or suppose your adultery case. Recently, the Supreme Court has struck down the provision of the adultery as enumerated in your IPC, or suppose 377 homosexuality. All of these recent cases, mainly in 2018, during the period of Chief Justice Deepak Misra, if you find the constitutional morality term has been used time to time in the various ways. Apart from that, the constitutional morality originally you will find in the Kesavan and Bharati, another landmark case of Kesavan and Bharati versus the state of Kerala, where you will be able to understand the first time the term constitutional morality was used. In that sense, you see these, you have to know what is constitutional morality. Another term is very much famous nowadays. It has become very much means appropriate. That is the transformative constitutionalism. Now we have seen what is constitutionalism. Another thing is coming the transformative constitutionalism. Now such type of constitutionalism which is being transformed from the time to time. In recent cases, in these cases, same cases, if you see, this is a very much new concept, and it is borrowed from your constitution expert. Mainly, if you see in India, this term has been borrowed by one book edited by Upendra Bakshi and others legal scholars, where the your constitution of the Brazil, constitution of South Africa, and constitution of India have been discussed very elaborately, and it has been found that though age-old provision or some mistakes were already there in the constitution, but you need not to follow it. It may be changed on the time to time, on the wave of the time. So if you accept those things, that type of constitutionalism is known as transformative constitutionalism. It's not the means it's nothing is hard and fast. So that's why from the time to time, with the demand of the society or as per development of the law and technology, we have to accept some principles, and that principle is that constitutional principle is the transformative constitutional. So we have later we have to discuss in detail, but we have to know all of these terms time to time when we will go to the constitutional provision, statutory provision. We have to understand apart from this constitution, constitutional law, constitutionalism, constitutional morality, and transformative constitutionalism from this 2020 perspective. Now come to our Indian constitution. Now all of these, whatever we have seen, that is the before going to the constitution. Whenever you will study our constitution, whenever Indian constitution will start, we will see that what is the structure of this constitution, how many chapters are there, how many parts are there, how many articles are there. So first we will find the preamble is there. Preamble is an important part of every constitution. Maximum constitution in the world, you will find preamble is there. Preamble is the theme of the constitution. So in Kesavan versus State of Kerala is a very famous case, landmark case, and means pillared case in the constitutional law, where it was decided that means it was held that preamble is the opening of the constitution. Means if we want to know the intention of the maker of the constitution, preamble is the key. So preamble, to the preamble, you can understand what was the object before the making of the constitution. At the time of the making of the constitution, what are the principles on which the constitution is standing, or means what are the pillars of the constitutions. So that's why before entering the constitution, before studying the constitution, we have to study the preamble to know the object of the constitution. If you see the Indian constitution in its present position, it has been divided into 22 parts. Parts are there like chapter, not a chapter, means some chapters have been constituted under the parts. So they are the 395 articles which have been divided into 22 parts. And apart from that, those are the 395 articles. Means if you see number wise, there are maybe the maximum numbers because so many amendments are there. Some A, B, C, D. In this way, articles are being increased. In spite of that, the number, the numerical 395 is there. Number now 395 is there. Now apart from that, there are the 12 schedules. These 12 schedules are also part of the constitution. So in this original, there was not the 12th schedule, there was the 8th schedule when the constitution was passed by the Constituent Debate Assembly. Originally, 8 schedules were there. Later, time to time, through the amendments, those schedules were inserted. So this is the structure. In this way, we have to proceed further. Now, before going to the constitution, we have to know the constitutional history also. This is another important thing. The constitution, without knowing the history, you cannot understand the purpose, object, scope, and origin of any statute or any kind of historical, any legal document. So that's why constitution is a historical document also. So the constitution, without knowing the history, you will not able to understand why this provision has been inserted, what is the source. So that's why in this way we have to first see that how this present constitution of the India was framed. You know, maximum this is a matter of general knowledge. Everyone is aware India that the cabinet mission plan was there. On the recommendation of this cabinet mission, there was a constituent assembly was formed. Constituent assembly, some members were there, where some were directly elected, some were representative from the states. And finally, the Constituent Assembly also formed one subcommittee, that is drafting committee. That B.R. Ambedkar was the chairman of this drafting committee. They drafted the constitution, and ultimately this constitution was also presented before the Constituent Assembly, and every provision, every article was very categorically analyzed, debated before the Constituent Debate Assembly. Those were mainly the process to make this constitution. Now, if you see the source of Indian Constitution is known as a bag of borrowings also. You know, when Indian Constitution is comparatively new constitution because it was formed in 1950 or during 1948 to 1949. During those period, on those periods, so many countries they had their maximum Western countries they had their constitution, established constitution. Apart from that, we got the maximum source of the present constitution was the Government of India Act 1935. It was the previous constitution during the British period. One constitution is just structure of the constitution was passed. That was the Government of India Act 1935. It was one of the major source of our present constitution. Apart from that, some British constitutional concept we borrowed in our time to time in our various articles, various provision you will find, very much proviso you will find that the essence of the British constitutional concept or Irish constitution or French constitution, US constitution, Canadian constitution, those impacts are there in our own constitution, Indian constitution. So those are the main sources at the time of the making of the constitution. Now some salient features are there. We will detail discuss about the salient feature, but just going to the entering the subject, we have to know some features are very much what to say, very much peculiar feature, which is only available in the Indian Constitution. But some basic features are also there. So here we'll discuss just the salient features, very much essential features of the Indian Constitution. Suppose the written constitution. Indian Constitution is a written constitution. It's one kind of written constitution. It's not we have already seen there are two types of constitution. One is a written, one is an unwritten. Indian Constitution is a written constitution. Written constitution means where the powers of the governments or the various organs of the constitutions are very much demarcated, very much written. It is very much in the four wall of the written constitution. That's why it is a written constitution, which is also known as a limited government. Government is limited. It is a welfare constitution. Welfare constitution, if you see, there is a part, that is a part 4, directive principle of state policy. Some directives are given from the constitution towards the state to adapt those policies. Those are mainly to attain India as a welfare state. The purpose of this constitution is to make the India a welfare country. This is not a police state or any kind of pressure is there. It is the free country and ultimate object of welfare of the country and citizen also. It is a modern constitution. New constitution we have seen. It's a comparatively very new constitution. It's not the Asian constitution. We have just completed 70 years, nearly 70 years. of this constitution. So in that sense, it's a new and modern constitution. So many provisions we find this is very much modern. Apart from that, it is a sovereign constitution. We know when we studied preamble, we see these terms have been used. Sovereign means there is no external forces. India is fully can make its own law. It's not it's dependent to any other foreign countries or any other countries. Socialist means we know that socialist structure is that welfare structure, and there is equal distribution of the assets or the properties are there. There is no capitalist structure, and there is you will find there is the provision also in Indian constitution where the distribution of the resources among the citizen equally. This is a purpose also. Secular constitution, there is no religion in our constitution. No means state religion is there, and at the same time it is protected our religion also. The constitution does not have any religion, or state does not have any religion, but citizen has a religion, and that religion should be protected by the constitution also. This right to religion is also one of the fundamental right. And democratic constitution also. Democratic constitution means government, this here government have been elected by the people, the democracy. Democracy, very age old theory is there, that the democracy means that Abraham Lincoln told, by the people, for the people, of the people. So that's the people have the very much benefit. When we see the preamble, we will see the preamble starts with the people of India. So it has been framed by the people. And republic. Republic means there is the elected head. Head of the institution is not the head. Any kind of monarchy is there or any kind of nominated head is there. The head is also elected directly or indirectly elected by the people. So this is a republic. Another salient features are there, that is a limited government. As we have seen that written constitution, one of the feature of the written constitution is a limited constitution. Limited government. Limited government means government's power are limited. It's limited by the constitution itself. And constitution has demarcated. Constitution has mentioned what is the power, what are the powers. Those powers are very much written. And judicial review. We'll see what is judicial review in detail when we will go to our articles of the constitution, but particularly we have to, before entering the constitution, we have to understand judicial review mean that any provision of the constitution as well as any statute passed by the parliament is subject to the judicial review. Judiciary can review means with the touchstone of the constitution. If any provision is not matching, or if any match is not in contrary to the provision of the constitution, judiciary can be not only any kind of statute, any kind of delegated legislation, any order, or any kind of means subordinate legislation, that is also subject to the judicial review. Next, government is the elected government. Another feature is the elected government. Our government, whatever government in the constitution, that is the elected government. That's not the nominated government. Or not there is any kind of martial law is there, or any kind of your power is there, means any kind of monarchical head is there. Neither for the family, not for any kind of monarchy, not for any kind of military power is coming. That whatever the government is, they are being elected by the people of India. This is the elected government. Three tier of government. Three tier of government means here India, you know, you all have the parliament, we have the Vidhan Sabha also, the state legislative assembly. One is the parliament and one is the state parliament. These two states. After 70, you know, 73rd and 74th amendment, or your this panchayat Raj system was also introduced. This is a local government. This is another set of government. So here one is the panchayat government or the local government, which is very known as the local government, panchayat or municipality, municipal board, whatever it may be, cantonment. But there is a local government, there is the state government, and there is a central government. So in that sense, there are three types, three tiers of government, three levels of governments are there. Apart from that, another salient feature is the bicameral parliament. This parliament has two houses. One is the upper house, another is the lower house. Upper house is the Rajya Sabha, lower house is the Lok Sabha. The Lok Sabha is mainly formed by the people directly elected, and Rajya Sabha people are being elected by the several states. Those Rajya Sabha members are representing the states, whereas Lok Sabha members, they are representing the people. That's a people's assembly, and another is the state assembly. Fundamental rights. Fundamental rights is another important chapter. Part 3 of the Indian Constitution is the fundamental rights. We have to study the fundamental rights. Means some rights are fundamental to the citizen or even the people of India who is not the citizen, who have visited the India, who are alien to the India. In spite of that, they have some rights which are very much fundamental. Is mainly borrowed from the UDHI when in means you 1948 when Universal Declaration of Human Rights was adopted by the UN. On that time, Indian Constitution was making. They have borrowed some idea, which is mainly the civil and the political rights. Second set of things are the directive principle of state policies. Those are the directive from the state, directive from the constitution to the state. States should adopt those policies. Those are mainly the socio-economic cultural rights. Apart from that, no rights is limitless. If you want some rights, you have some duties also. But there are some fundamental duties also in the Constitution. Originally, it was not there. It was inserted after 42nd Amendment 1976. It was introduced, and this is mainly borrowed from the concept of these communist countries, or you may say that some those countries, suppose Japan or suppose Czechoslovakia. If you see those countries has a practice of following the fundamental duties, even citizen, they have some duties toward the state also, and that chapter was inserted in our constitution through the 42nd Amendment in 1976. That is a part 4A. That is the fundamental duties. Now, ultimately, if you see the nature of the Indian Constitution, what is it? It is the federal or unitary. Two sets of government we have already told. We have already seen that one types of constitution is known as a federal constitution, where powers, there's all kinds of power, legislative power, judicial power, executive powers. Those powers are distributed between the two sets of government. One is the state government, other is the central government, the national government, or your territorial government. And one set of constitution which is known as unitary constitution. Unitary constitution means those constitutions where there is no such type of distribution between the state and the union. It's the only one form of government is there. That is the unitary government. So Indian constitution, if you see, it's not the strictly sense. In strict sense, it's the federal constitution. It has some features which are very much federal in nature. Very essential features of the federal constitution, those are present inside the Indian constitution. In spite of that, some provisions are there when Indian constitution is treated very much unitary in nature during the emergency, or some provisions from time to time we'll discuss, we'll see those are very much unitary in nature. So that's the unique blend of your federal constitution as well as united constitution, and some provisions which are modified form of the federal constitution. So that's why in that sense it is known as a quasi-federal constitution, not the strict sense of the federal constitution. What is the quasi-federal constitution? So Indian constitution nature is the it's another salient feature. It's a quasi-federal constitution. Hope it's all about the basic salient features and our Indian constitution.